Good morning, everyone. Today we will discuss one more important topic in polity subject, that is right to freedom. Okay. Okay. Within right to freedom, we will specifically discuss about Article 21. Okay. Article 21 is the important article in the Constitution. According to me, it is the most important topic. Article that is mentioned in the Constitution of India. Okay, right. What is Article 21 is saying? Article 21 is saying that there is right to life and personal liberty. Right to life and personal liberty in the for every person there is right to life and personal liberty. You have to remember that this right is available to all the people of India. All the people who are there in India means it is applicable to both citizens of India and including non-citizens. Okay, non-citizens means it is also available for foreigners. This is the major difference between Article 21 and Article 19. Okay, Article 19 is not available for non-citizens, means it is available only for the citizens. Okay, we have seen everything about Article 19. What are the things what are the 6 freedoms that have been guaranteed under Article 19? Of course, there were 7 freedoms, and one freedom has been removed, that is related to property, and basically it is guaranteeing 6 freedoms or 6 liberties, okay, to the citizens of India. We have seen that in Article 19 in full detail. We have seen about that one. Okay, and one more thing you have to remember, that both these articles 19 and Article 21 are closely related. Okay, how they are closely related we will see. Okay, when we understand about Article 21, then you will see how they are closely related. Okay, right. So what Article 21 is saying? Article 21 is saying there is right to life and personal liberty. Okay, there is right to life and personal liberty. This is what broadly we will see the text. What exactly the text is saying, we will see that. We will come to that. But briefly, we will try and understand what is the essence of Article 21. So Article 21 is saying there is right to life for every person and there is personal liberty. Okay, right. What is the meaning of right to life? Okay, what is the meaning of right to life? Right, is it it's like, okay, life means we are alive, and if right to life is not guaranteed under Constitution, if you are died also there is no problem. Okay, or the state makes us to like, let's take an example. If the government kills us, so that is allowed, if at all there is no Article 21 in the Constitution. Okay, of course our right to life is ensured, that we have the right to live and continue our life until the natural death. Okay, until the natural death occurs. Okay, so the government is not allowed to take away our life. That is, of course, that is there. But you have to understand, you have to little bit go forward, and you have to understand that right to life means, here you have to read like this. Right to life means right to good life. Okay, right to good life. Or you can interpret like this: right to dignified life. Right to dignified life. Okay, so the actual substance or actual meaning of right to life is this one. Right to life means, according to Article 21, the right to good life, or and the right to dignified life. What is the meaning of good life? Good life is right to we are living means it should not be like a mere animal existence. Okay, animals are also there. Of course, they have the their own rights. They also have the right to live. But you see, compared to human beings, generally we consider their rights are inferior. Okay, of course, they are, animals also have their life. Okay, they live their life, like that. There is no special purpose for their life. Okay, they will, they are gone, they will live their life, they give birth to their offspring, that's it. Okay, there is no special purpose like the human beings have. Okay, and the human beings life shall not be like a mere animal existence. Okay, meaning we shall not be just living for the purpose of living, that's it, only for the purpose of living. Then it's not like there is no other purpose for the human beings. There is lot of purposes for the human being, and there should be lot of purposes, like we have to be educated. Okay, and we have to develop, and we should be having some goals and ambitions, and we shall have opportunity to achieve those goals. And it's like we should get respect in the society. Okay, then we should be meeting all our needs. Okay, especially the basic needs like sufficient food to eat, clothes to wear, and cover under above our head, so that we can have a proper shelter. All these basic needs shall be met. Then we say that is a dignified life, and that is a good life. Okay, to this you include proper health also, good health. Then you include that proper livelihood. Okay, so that we can earn money and secure our basic needs. That is the meaning of good life or dignified life. Okay, so what right to life is saying, right to life, what is the exact or broad meaning of right to life that is guaranteed in article 21, that is right to a good life and the right to a dignified life. Okay, and the state shall not deny any person this right to good life and right to dignified life. In fact, it should make efforts so that citizens or people of India are having a good life and a dignified life. That is the meaning of, that is the actual meaning of right to life. Okay, of course there is security, our life is guaranteed. There shall be only natural death, and the state should not take away our life arbitrarily. That we will understand when we see the text of the article. But including that, there is this meaning also. Okay, that is the meaning of right to life. Okay, and you will understand this later when we see the various judgments of the Supreme Court. You will understand this concept, how it has interpreted the concept of right to life. Okay, right. Then we will come to this part, right to personal liberty. Okay, we have already seen under article 19 right to liberty. Of course, this article 19 to 22 are, they have been covered under right to freedom. Okay, right. 19, 20, 21, 22, these four articles are talking about right to freedom. Especially the article 19 gives us liberty. We can call this article as right to liberty. Okay, here we have guaranteed six freedoms. Okay, that is what mentioned in article 19. We have seen that right to freedom of speech and expression, first liberty. Right to assemble, second liberty. Right to association, third liberty. Okay, then right to movement, fourth liberty. Then right to settle, any right to movement across the territory of India, that is fourth right. Right for settlement or right to settlement, that is the fifth liberty. And the sixth liberty is right to take up any profession, trade or business. Okay, in any part of India. These are the six freedoms guaranteed to the citizens under article 19. Okay, then why once again there is a mention of this liberty, personal liberty under article 21? Why? What do you think? Right. So in the liberties that are guaranteed under article 19, they are specific liberties. Okay, they are very specific. Only 6 specific liberties have been given. Of course, the liberty is not limited to these 6 things, right? There are several other things with respect to liberty. Okay, and all these broader other liberties that are not covered under Article 19, they can be interpreted or they can be found in this Article 21. Okay, in this way I told there is a relation between Article 19 and Article 21. So where this Article 19 ends with respect to liberties, okay, where it ends, Article 21 will start. Okay, right. For example, a small example I want to give you. Article 19. Okay, in 6 freedoms it is giving. Then fourth freedom is right to movement across the territory of India. Means within the territory of India, you can move anywhere. Of course, there are reasonable restrictions. Except those reasonable restrictions, generally, citizen of India has right to move to any part of India. Okay, that is the liberty guaranteed. Then what if a person wants to move out of the country? He wants to cross India and go to some other country, United States of America or UK, any other country. Okay, that person wants to visit a foreign country. Okay, then what is it? So it should be allowed or not? That liberty should be there or not? Of course, in normal circumstances, it should be there. Then where that liberty is covered? Okay, then the Supreme Court said that liberty to move out of the country, okay, that can be found under Article 21. Okay, in this way, Article 21 with respect to liberty, Article 21 is the extension of Article 19. Okay, where the Article 19 stops or ends, from there Article 21 will take up with respect to personal liberty. Okay. This is the meaning or broad understanding of Article 21. What Article 21 is exactly saying. Okay, right? You understood it, right? Right. This is the meaning of Article 21. Okay. Then we will see what is exactly the text. What exactly the text of Article 21 is saying. Right? Can anybody repeat, say what exactly Article 21 is saying, or what is the text mentioned in the Constitution of India with respect to Article 21? The text of Article 21 is written like this. Okay, Article 21. What is it saying? No person shall be denied. Okay, no person shall be deprived of right to life and personal liberty except, okay, until here we have understood. Okay, no person shall be deprived of right to life and personal liberty except according to, or except according to also you can write, or under the procedure established by law. Okay, this is very important. Procedure established by law. Okay, right. This is the text. No person shall be denied, or you can write like this also. The state shall not deny to any person. State shall not deny. Okay, any person the right to life and personal liberty except according to the procedure established by law. You remove this one, no need for under. Okay, except according to the procedure established by law. Okay, right. So until here we have understood, okay, the state shall not deny any person the right to life and personal liberty, or no person shall be denied or deprived of the right to life and personal liberty. Okay, until here we have understood. This is what guaranteed under Article 21. Okay, the right to life and personal liberty. We have understood this part, but there is a limitation. Okay, there is further text is there in the article, right? The further text is saying that, but this right to life and personal liberty can be taken away, okay, according to the procedure established by law. Okay, so if a law is there and the law is establishing a procedure, it laid down a procedure to take away this right to life and personal liberty, then in that case this right to life and personal liberty can be taken away. Okay, this is the exception. Okay, right, except according to the procedure established by law, no person shall be denied right to life and personal liberty. What it is implying, if parliament makes a law, okay, if there is a law and if any person is violating that law, example, I am violating certain law, a law is there, earlier criminal procedure CRPC used to be there, now we have BNH, Bharatiya Nyaya Samhita. Under this I am violating something, okay, let's take an example, I am murdering a person, okay, murder, let's imagine I am murdering a person. So murder is a crime under BNH, presently under BNH it is a crime. So under this law the police will arrest me, okay, they will submit me in the court and court will examine my case and it will find that I am guilty, I have murdered a person called X, and according to that under BNH I am eligible for 5 years of prison, or I shall be punishable with 5 years of imprisonment. Then for the 5 years I have put under prison. Okay, so when I was put under prison, or when I was put in prison or jail, my right to life and personal liberty has taken away or not? It has taken away. Now I will not be allowed to move out of the prison. I should remain in the prison or jail, right? In that way, my right to freedom of movement, okay, move out of the prison and do whatever I like, that has been taken away, right? So how it has been taken away by the government? There is a law, that is BNS, Bharatiya Nyaya Samhita, and according to that law, my right to life and freedom of personal liberty has been taken away. Okay, this is the meaning of procedure established by law. Okay, BNH, Bharatiya Nyaya Samhita. Okay, BNS, it is a law. Okay, this law has established a procedure for a certain act, okay, a crime, and according to that procedure prescribed by this law, my liberty has been taken away. My right under Article 21 has been taken away. That is the meaning of procedure established by law. Okay. So the government or the state cannot take away our right to life and personal liberty except the government can take away the right to life and personal liberty according to the procedure established by law. Okay, let's imagine one more thing. The murder, I have committed a murder, but imagine I am a serial murderer and I have murdered all the family members, including children, women, everybody in the family. Maybe I have an interest on their property. They are having huge property, huge lands. I want to get those lands. So with that intention, I have killed all the family members. That is a heinous crime, worst crime. Okay, and that will fit into the definition of rarest of the rare cases. Okay, in that case, I can be given death penalty. Okay, death penalty. So I will be hanged till death. Okay, in this way, the government or the state is taking away my right to life. Okay, once I am hanged, I will no longer live. I will be dead. So in that way, the state is taking away or depriving my right to life. Okay, but it is allowed because there is a law. Once again, there is a law which is saying, okay, if a person commits this crime, that person's life can be taken away. That person can be, death penalty can be given to that person. Okay. So, right to life and personal liberty can be taken away if there is a procedure established by law. Only under that procedure established by law, okay, only under that procedure established by law, the right to life and personal liberty can be taken away. Okay, right. So that is why, to make sure that no, the law itself is not arbitrary. That's why before Article 21, we have an Article 20. Okay, we have Article 20, which is giving, which is, protecting, once again, protecting the people from arbitrary arrest. Once again, we have already seen three sub clauses are there, or three clauses are there in Article 3. Okay, that is ex post facto, crime, ex post facto punishment, punishment given only for the acts, acts that amount to criminal acts at the time of commencement of that crime. Okay, that is the first class. Then no double jeopardy, means a person cannot be punished for more than once for the same crime. Then the third one is no person shall be compelled to give evidence against himself or herself. Like that, already three protections have been given under Article 20. Okay, to prevent to prevent the government from arbitrarily taking away the right to life and personal liberty, though there is a procedure established by law. Okay, that is why already protections are given under Article 21, and in Article 22 also you will see other protections. Protections when a person is being arrested under normal circumstances or under normal law, and protections for arrested persons are there who are arrested under preventive detention, PD. Okay, under preventive detention laws. In this way, lot of protections are being given for the people, okay, citizens, so that the state shall not be taking away the right to life and personal liberty in an arbitrary manner, okay, forced manner, by just normally bringing a law. Okay, that is the meaning of procedure established by law, and protections are given under Article 20 and 22 for the arrested persons. Okay, right. So this is, in this way we have to study all the articles in a comprehensive manner. Then only you will understand the actual intention, what the constitutional makers have actually thought. Okay, right. So now we will go and go forward, and we will see. Okay, we will see. Earlier, or before that, we have to discuss one more thing. The Article 21 is saying that, okay, the state has, the state can take away the right to life and personal liberty of the person according to the procedure established by law, right? Okay. But what do you think? Can there be a situation where the law itself is wrong? A situation like that will be there, right? Article 21 is saying generally people have right to life and personal liberty, and that can be taken away when a proper procedure is there, a proper law is there. That is what it is saying. But do you think, what do you think? Does law always be correct? Law can be made with malintention also, right? All the laws that are there. If parliament, good people are sitting in the parliament, and they are working for the good of the people, or they have kept the interest of the people, they can make good laws. Okay, but there can be bad laws also, or laws made with bad intention. That is also possible. Okay, then those laws are not just means not justifiable. Okay, they are not ethical. Such type of laws can be there. Okay, I will give you examples from the past history. Okay, A little bit we will go into the history and we will see the British time, okay, Britishers time. So we will take the period during Britishers, okay. Um, what they have done, okay, they used to say that okay, whatever we are doing according to the law, okay. Of course, they have their final motive is to exploit India and to get a grip on India as much as possible, okay, to get full control on India, okay, and instead of doing they doing it directly, they have done everything through laws, okay. Best examples I will give you. We will take the example of Jhansi Lakshmi Bai, okay. What happened in our case? Her husband has died. She did not had any biological male child, okay, son, that to biological male son. So she has adopted a child, okay, adopted a child, okay. And the Britishers have said that look, your the adopted son is not a legal heir, okay. Your adopted son is not a legal heir because the child is not your biological son, okay. And biological son, and because that son is not child is not a biological son, he will not become a legal heir. So after your death or after your husband's death, you people do not have any right on your kingdom, the kingdom of Jhansi. It obviously it belongs to the Britishers, okay. That is what they have said. Then what is the law that is saying like this? Then they have said, look, our parliament is there, British parliament, okay, and it has enacted a law. Means simply the governor general himself passed a law like that, okay. It's like that Parliament of India, the parliament, British parliament has passed a law which is saying, okay, in India, okay, in India, if any king or queen, they are not having a biological, or for the kingdoms of India, with respect to inheritance, there should be a biological male child or male offspring will be considered as a legal heir, okay, and adopted children will not be considered as legal heir, okay. If a king or queen dies without this legal heir, biological male offspring, then after their death, because no legal heir is there for that kingdom, that will be coming under the British rule, that will become part of British India, okay. This is what the British Parliament has passed. The British, people who are ruling in India, the Governor General, other governors, okay. All these people are saying, look, Jhansi, Queen of Jhansi, you do not have a legal heir according to this law. So that's why we will take away your kingdom. Okay, this is what saying. Okay. So now you think, is this law is logical? Is it justifiable? Is it ethically correct? This law is ethically correct? No, it's not. It is not ethically correct. Okay. Simply, it's with common sense you can understand that this is an unethical law. Simply, you cannot prescribe some random conditions. Okay, who will become a legal heir and who will not become a legal heir, and you cannot just take away the kingdoms who are belonging to Indian kings and queens. Okay, so this law itself is wrong, right? Then what is the solution in these cases? Okay, now you bring it, you try to understand it with the context of Article 21. Article 21 is guaranteeing right to life and personal liberty, and it is saying that okay, the government can take away the right to life and personal liberty according to the procedure established by law. Okay, in this law also, this is the procedure established by this law, and the people who are implementing this law, people are nothing but they are also part of the government employees who are implementing this law. They are saying that simply look, there is a procedure under this law and we are following that procedure, and the procedure says this your kingdom can be taken away when you do not have the legal heir, That is why we are taking away your kingdom. Okay. So that is what now presently also a government, okay, if it wants to suppress certain people, maybe political opponents, okay, that political opponents might have done something or they are expected to do something, so it can bring up a random law, okay, prescribing A, B, C, D, E, F, G conditions. If a person will do this, any of this, that person can be arrested and put behind the bars, and that person can be awarded death penalty. In that way, government can bring in a law, random law, which will prescribe a certain procedure, and under this random law, the right to life and personal liberty of a person can be taken away. Is that possible or not? Yes? Right. That is possible. There is scope for misuse. Okay? Right. So what is the solution in that cases? What is the solution in those circumstances? The solution is, okay, the solution is, actually that was happening until 1978, okay, until 1978, the Supreme Court has the power to interpret the Constitution, and under Article 13, Article 32, and Article is the High Court under Article 22, 28, they have the judicial review power. Okay. Article 13 says, if any law before the commencement of the Constitution or after the commencement of the Constitution, if any law is against the Constitution or against the fundamental rights, the law will become null and void. Under Article 32, the Supreme Court can issue writs. Okay. Under Article 228, the high courts also can issue writs. So all these things will give the power of judicial review to the courts. Okay, right. And moreover that the power to interpret the Constitution or provisions of the Constitution has given to the judiciary. This we know very well. Okay. So until 1978, the Supreme Court also, or the judiciary of India was also literally following this concept. Procedure established by law. Procedure established by law. Right? Means if a law is there and okay, a person's liberty is taken away, and that taking away of liberty or life is according to the procedure prescribed by a law, then the Supreme Court has accepted it. Okay, that is what happened. We will take the examples of the cases. We will try and understand this with cases. Okay, so in 1950, immediately after the commencement of the Constitution, a case has come, that is A.K. Gopalan case. Okay, A.K. Gopalan versus State of Madras. Okay, in this case has happened in 1950. Okay, A.K. Gopalan is a communist leader, or was a communist leader. He was arrested. Okay, he was arrested. He was a communist leader. At that time, the party which was in power was the Congress party. Jawaharlal Nehru was the prime minister. And in most of the states, almost all the states, Congress party led governments were there. So this A.K. Gopalan was a communist leader. He was arrested under PD laws, preventive detention. He was under preventive detention. Okay. Then he challenged his arrest under PD Acts in the Supreme Court. Okay. He said that A.K. Gopalan argued that my right to life and personal liberty has been taken away. Okay. So you judiciary protect me. Okay. Restore my right to life and personal liberty, because I have been arrested under PD law, preventive detention law, and this is illegal confinement. My liberty has been taken away. So you restore my this one. Okay. Liberty. Then Supreme Court said that the government which actually arrested this person is argued that, look, there is scope for preventive detention laws in Article 22, and according to that we have made preventive detention laws, and there is a procedure established Article 22 itself is saying that a person can be arrested, put under preventive detention for 3 months without any trial. Okay, the constitution itself is saying that. Okay, so that is why we have arrested this person is expected to commit certain crime. If this person is in open society, this person is capable or he is trying to disturb the public order or law and order. That is why we have arrested him. Okay, then what the Supreme Court said, yes, there is a procedure established by law. There is a law that is saying a person can be, according to that procedure, a person's right to life and personal liberty can be taken away. Okay, the government is right in taking away your right to personal life and liberty. Okay, according to the procedure established by law. Okay, procedure established by law. Okay, right. Then it accepted the arrest of A.K. Gopalan. Okay, in this way, the Supreme Court has followed this doctrine of procedure established by law, and we can say this is the narrow interpretation of the Article 21. Okay, interpretation of Article 21. Okay, right. Then 1978 came, okay, from 1975 to 1977. 1975 to 1977, we were under what? We were under emergency. Okay, so after 1977, this emergency has been lifted and elections were conducted. Under that, Congress party has defeated and Janata Party came into power. Okay, Janata Party came into power, and you have to remember that at that time Maneka Gandhi, okay, or Menaka Gandhi, she is more popularly known as, presently she is associated with Bharatiya Janata Party, but at that time Maneka Gandhi was a journalist and she was a social activist also. She was a well-known journalist by that time, and you have to remember that she was also the wife of the son of Indira Gandhi, Sanjay Gandhi's wife. She was the wife of Sanjay Gandhi. So she was supporting the Congress party. After the imposition of this emergency, Congress party became, very much unpopular, and it got defeated. After that, Maneka Gandhi was trying to restore the credibility of Congress party. Then Janata Party came, and Janata Party tried to control Maneka Gandhi, okay, in her efforts to restore the credibility of Congress Party. Okay, and when her activities have been prevented in India, she tried to go to some other country, maybe United States of America. Okay, then realizing that this Janata government or government led by Janata Party suspended her passport. Saying that if Maneka Gandhi leaves the country, she goes to other country, it becomes very difficult to control her, and she may continue to do the activities that may hurt the interest of India. Okay, that is what they have thought, and that's why they have suspended her passport. Okay, what happened when this passport of Maneka Gandhi has suspended? She cannot leave the country, because without having passport, it's very difficult to leave. You cannot leave the country. Okay, then she challenged this decision of the Janata government in the Supreme Court. Okay, so then this happened in 1978. Okay, this case came to be known as famously as Maneka Gandhi versus Union of India. Okay, and in this court, the Supreme Court examined that the government has suspended her passport, so this is curtailing her right to liberty of movement. Her movement has been curtailed. She wants to go out of the country, right? But the government is not allowing that, so her right to movement has been curtailed. Okay, her liberty has been violated. Okay, then the Supreme Court asked the government, on what basis you have prevented her from moving out of the country? Then Supreme Court, the government said, look, there are various acts like Passports Act and Immigration Act, like that many acts are there, under which the passport of a person can be suspended. Okay, so look, there is a Passports Act, and under that we have suspended her passport. The government said, look, there is a procedure, there is a Passport Act, there is a law, and there is a procedure prescribed under it. According to that, we have suspended her passport. Then Supreme Court said that okay, you are saying there is a procedure, there is a law, but mere existence of law is not sufficient to curtail the freedoms of the people. That law should be just, okay, it should be just, it should be fair, okay, and the law should be reasonable. Okay, just that person is working against the government, he is criticizing the government, and she is working for an opposition party. You cannot take away her right to movement. That is unreasonable. So how a law should be, not only just mere existence of law is not sufficient. That law should be just. These words are very very important. You remember them very carefully. A law should be just, a law should be fair, and a law should be reasonable. Only under that law and only according to the procedure established by that law, you can take away the right to life and personal liberty. Otherwise, if a law is unfair, if a law is unjust, if a law is unreasonable, you cannot take away life and liberty under that law. Okay, so in this way, mere existence of law and the procedure established by law itself is not sufficient. Moreover, the law itself shall be made by following a due process. Okay, due process means a proper process should be followed in making a law. Okay, the law which is taking away the life and liberty of a person. Okay, in this way, in 1978, the new doctrine has been found out in Article 21. Right to life means, under right to life and personal liberty, according to Article 21, not only procedure established by law is there is also due process of law. Okay, there shall be due process of law. Due process of law shall be followed. What is this due process of law? A law should be just, fair and reasonable. Okay, and that law should be made properly. Okay, then only under only that law or only under procedure established by that law, justified law, you can take away the right to life and personal liberty of a person. Okay, so in this way, the Supreme Court in this case started broadly interpreting Article 21. It invented the concept of due process of law in Article 21. Okay, since this year, from here onwards, the Supreme Court or judiciary started interpreting article very very broadly. After that, you will see various judgments are there. Okay, all right. So this is the concept of procedure established by law and the due process of law. You remember, originally the Supreme Court was not mentioning due process of law until 1978. It was simply following the procedure established by law, and the interpretation is also very narrow with respect to Article 21. And after that due process of law, after from the Maneka Gandhi case onwards, the Supreme Court started interpreting Article 21 very vastly. Okay, right. I hope you have understood this concept. Now the concept of procedure established by law and due process of law. Okay, procedure established by law. Okay, and due process of law. Okay, so you have understood this is explicitly mentioned in the Constitution, and this is not explicitly mentioned in Constitution. Okay, So this is a narrow interpretation of Article 21. This is a broad interpretation of Article 21. Okay, it is explicitly mentioned. Okay, explicitly mentioned. This is not explicitly mentioned, but it is a judicial innovation. Okay, judiciary in 1978 found out. Okay, and where this concept we have taken from? We have taken it from British law. Okay, procedure established by law is followed in Britain. Okay, it is has British origin. Okay, due process of law has the origin in United States of America's law. Okay, so the judiciary of United States of America, the federal court, has found out this due process of law, and it was inserted later. It was inserted into the Constitution of USA through certain two amendments are there. I think Fourth Amendment and the 15th Amendment, like that. I do not exactly remember the number of amendments, but through I think 4th and 15th Amendments, it was later inserted into the Constitution of USA also. From there, our judiciary has taken inspiration, okay, the inspiration for due process of law, and our judiciary has invented this due process of law in Article 21. Okay, here simply mere existence of law is sufficient. Mere existence of law is sufficient, but here the law should be just, fair and reasonable. Okay, and simply here we are following the text of the law. Okay, simply we are following the text of the law. Simply we are blind following of the law. Okay, text simply we are following the letter of the law. Here we are following the spirit of the law. Okay, right. Okay, these are the broad differences, between the procedure established by law and due process of law. Example here is the A.K. Gopalan case. Okay, A.K. Gopalan case of versus A.K. Gopalan versus State of Madras, 1950. Here the example where the due process of law has been invoked is Maneka Gandhi case. Okay, these are the differences between procedure established by law and the due process of law. This is very important concept. Many people will get confused in understanding these two concepts. Because of that reason, I have taken various examples, multiple examples, and I have explained it very clearly by taking help of all the articles and the stories, what actually happened behind these cases, etc., etc. Okay, I hope now you understand. Now you have understood the both the concepts under Article 21, procedure established by law and due process of law. Okay, right. So after in 1978, this due process of law has been invented under Article 21, and since then the Supreme Court has started interpreting Article 21 very widely. Before that, only narrow interpretation was there. Okay. Right. So finally, after 1978, we will see how broadly or in which way the Supreme Court has broadly interpreted the Article 21. Okay. 1978, it said due process of law is there. Okay, in our constitution, in under Article 21, under right to life and personal liberty. Okay, after that it said that there should be proper right to livelihood. Okay, livelihood, right to livelihood is there under Article 21. We have understood right to life means right to a good life, right to a dignified life. So what is the meaning when a person is not able to meet his or her basic needs along with his family? So to earn those basic needs, proper job should be there, livelihood should be there. So right to livelihood is invented as a fundamental right under Article 21. Okay. Then in 1992, in Mohini Jain versus Union of India case, court said right to education is a fundamental right. Okay, right to education is a fundamental right. Mohini Jain case. Okay, it said that right to life means right to dignified life. So how dignity will come? Dignity comes and flows with education. Okay, so that's why the court said right to life, right to education is a fundamental right. Okay, this judgment came in 1992. So accordingly, in 2002, the government has or the parliament has amended the constitution and it inserted Article 21A, which is guaranteeing right to education for the children between 6 and 14 years. Okay, this is free and compulsory education, elementary education for the children. Okay, right. We will take the latest judgment 2017. Okay, right to privacy. Okay, under article in 2017 in Aadhaar judgment, Puttaswamy versus Union of India case, Aadhaar famously it is known as Aadhaar judgment. In that, the government said that people have right to privacy under Article 21. Okay, their privacy has to be protected. Okay, before that, okay, there was government said that people also the judiciary has said that people also have fundamental right to health. Okay, and clean environment. Okay, environment in MC Mehta versus Union of India case. Okay, so people have right to life. So that right to life is threatened when healthy conditions are not there, healthy environment is not there, or people's health is not protected, and clean environment is not there. Okay, because of pollution, people's health is being impacted. Because of that, they are losing their right to life. So, right to health and clean environment is the fundamental right. Okay, accordingly, in Delhi, the diesel buses have been withdrawn and LPG buses, CNG buses have been introduced during 1990s. This is a famous case in which MC Mehta challenged the Delhi government's practice of running diesel buses that was causing huge pollution in the city of Delhi. Because of that, Delhi, diesel buses have been withdrawn and CNG buses have been introduced. Okay, in this way, the Supreme Court has started broadly interpreting the Article 21. Many other things are also there, like right to sleep. The Supreme Court said that right to sleep is also a fundamental right. You cannot take away. Okay, like that, many other rights also have been interpreted as the time passed by. Okay, this is the broader interpretation that has been done by the Supreme Court after the Maneka Gandhi judgment. Okay, right. So this is broadly about the Article 21. I have made sure that all aspects related to Article 21 are covered here. Okay, I hope you have understood, especially the concepts of procedure established by law and the due process of law. Those are very, very important from the point of view of examination. Okay, right. So we will stop this here. In the next class, we will learn something about a different fundamental right, maybe the right against exploitation. Okay, right. Until then, you have a good time. See you next time.